I'm Noelle Dupuis. I'm the Director of Policy and Attorney with the Illinois Coalition Against Domestic Violence.
And I'm Jennifer Bishop-Jenkins, the Director of Marsy's Law for Illinois.
I'm Tyler Edmonds. I'm the Union County State's Attorney.
Megan Jones-Williams. I'm the Program Coordinator for Rape Crisis Services at the Women's Center.
Are you good?
Okay.
I guess if you guys want to just give us the, the information this has to do with the bill of, something that's going to be on the ballot in November.
Yes.
Okay.
So, we have a very long story that goes along with the Crime Victims Bill of Rights. This has been many, many years in the making. Back in 1992, a set of numerable rights were put into the Illinois Constitution for crime victims. As a part of those negotiations that happened during 1992, an enforceability mechanism was left out. And that was done on purpose. Those were compromises that we made in 1992. We just needed to make sure that we had language within the Constitution. In 2008, Attorney General Lisa Madigan convened roundtables across the state, 5 different roundtables, to talk to victims to see how is this actually going now that we've had this in our Constitution for so many years. And what we found out that while many victims' rights are respected by our prosecutors and our judges, a lot of them were being violated. And victims had no standing to assert their rights in court. Judges were telling them, you do not have the right to stand up here, and because you're not a third party to this criminal case, you have no right to stand up and have your rights respected. So if her right was violated, she can't stand up and talk to the judge about what is happening to her. She also can't appeal those decisions that the judges were making. So we go to the drawing board and come up with language to fix the Constitution, because Illinois is the only state in the Union that bars appellate relief, that creates that bar for victims to not be able to go and appeal any of these decisions that are made. We almost passed the language in 2012 when the State's Attorneys Association came out against the Bill of Rights. And so my organization, the Coalition Against Domestic Violence, the Coalition Against Sexual Assault, and Marsy's Law for Illinois, we went back to the drawing table and said, hold on, if our prosecutors have a really big problem with this, we need to revisit this language, and we've got to come up with something better, because we want to make sure that our prosecutors are happy and that we can hold our perpetrators accountable while still respecting victims' rights. So we met over the course of November through December in 2013 with, I think, over 25 different state's attorneys within their counties. 29, excuse me. Yes, there was a lot of driving. We did a lot of driving. We went to them and we sat down in their districts, and we sat down with their local advocates, their sexual assault and domestic violence advocates, and we talked with them about their concerns. And we came together eventually after a lot of negotiations to come up with the very best language for the state to make sure that our prosecutors still have the tools to do what they need to do in holding perpetrators accountable, but at the same time that victims can have their rights respected and redressed. So that's the long story about how it came to be on the ballot. It went through the General Assembly almost unanimously in the Senate, 2 votes against in the House, which is just about as close to unanimous as you're possibly going to get in the Illinois General Assembly. Now we have it on the ballot, and we need everybody to know that it exists, most of all. A lot of people ask us, what's your biggest challenge? And it's just that most people, fortunately, are never going to be crime victims of a serious violent crime. And so they might see it on the ballot and not understand what it is and decide, well, I'm not educated enough on it, and I'm not going to vote either way. So we need people to know that it's out there and that it's going to make a real difference in victims' lives. And Jennifer can tell you more about her story. I can tell you about domestic violence victims in particular and how this will affect them, but I will let Jennifer talk about her story, and then we can revisit domestic violence victims as a category if you'd like.
Right, and there is a lot there,
yeah.
Especially during October.
Which is Domestic Violence Awareness Month.
So my name is Jennifer Bishop-Jenkins, and I'm the Director of Marsy's Law for Illinois, and my sister, her husband, and their baby were murdered some years ago in suburban Chicago. I never knew anything about the criminal justice system. I was a high school social studies teacher. I knew the stuff I taught in civics class. I never knew that victims had rights. I never knew that those rights could be violated. I never knew that those rights in Illinois, if they're violated, cannot be fixed. There's actually a constitutional bar against remedying it by appeal. So I didn't know any of those things. And what happened to us is, after my sister, her husband, and their baby were murdered, it was an agonizing process. I don't even need to go into that conversation. I'm sure you guys can imagine. It's permanently life-changing and devastating beyond words. And then to go through, first who did it, and then catching him, and then arresting him, and then he goes to trial, and there was, 18 months of legal proceedings, and then finally to have, our day where he finally was convicted and found guilty of these horrible crimes. And my sister was 25, and she was pregnant, and she was begging for the life of her baby, and he deliberately shot her in the abdomen, aiming for the baby. It was a horrible crime. And so we were living for that day when we could make our victim impact statement at sentencing. And I had already written mine. I was all excited about it because, we'd waited 2 years to finally be able to look the guy in the eye and say, this is what you took. This is the damage that you did. Because to this day, he doesn't get it. He just doesn't get it. And more important than looking him in the eye is getting it in the court record of the case. Having the description of Nancy and Richard and the baby and what their lives were, how horrible their deaths were. To have that as part of the official court record, that was very important to us. And we got a phone call from the court, literally the day, it was the day before, late the day before, saying, don't come. We are not going to take victim impact statements. Sentence is mandatory, it's a life without parole mandatory. We're just not, it's not going to change anything, so we're just not going to do it. And don't bother to come. We don't want to bother you, take off work or whatever. I mean, I was in shock. We were devastated. I think at the time we were all just so numb from it all. We just kind of like, okay, we'll do what we're told again. We didn't want to be not cooperative. We wanted to be cooperative. But I didn't know that that was actually my right to do that already under the Illinois Constitution, and that I could have, we could have, tried to at least assert that right, except that I also didn't know that under Illinois law we are not allowed, because we don't have what Noelle described as standing in the case, the legal recognition as victims in the case, that we actually have some official legal relationship to the case. I didn't even have standing, my mother and father did not have standing to file any kind of motion saying, please let us make these victim impact statements. So we were not allowed to do that, and that didn't happen. And all these years later, it still matters to me a great deal, and it still matters more even than not having said to him, but that it's not in the record, because now the killer actually, as we were just talking in the parking lot, the killer has a new possible appeal. And cases that were all the prosecutors are, about 100 cases statewide, may get all new appeals based on the Supreme Court ruling. And now he's back in court again. So once again, we're faced with the fact that that court record from that trial is incomplete because we didn't have the victim impact statements. Now, I don't pretend that what happened to me harmed me the way that I have seen other much more serious victims' rights violations. I have since had the very great privilege of working now with crime victims statewide, and I've heard some horrible stories of people put in danger because they didn't know of the release of an offender. We even know of one young lady, Jamie Foster, whose family has given us permission to talk about her. In fact, Jamie's mother has even appeared in one of our video commercials. Jamie died as complications of her injuries, a result of complications from her injuries, after a beating that she got after the guy was released. A second time he beat her up once, and then then it happened again. Ultimately she died of medical complications from her injuries, all because in both of the aggravated domestic batteries, she was not notified of quick decisions that were made in the case and quick release that was made of the guy was let go. So we know that this is dangerous when victims aren't told what's happening in their case. It can actually be life-threatening. It can certainly be psychologically damaging. And we have seen victims whose privacy has been violated because, for example, the case that I understand got the Attorney General's attention was a rape victim whose diary was subpoenaed by the defense, had no material evidence in it with regards to the rape at all. It was just her past, and they were trying to besmirch her past, and they were trying to make somehow the accused look less guilty. And there was no legal grounds under which she tried to object. Why do they get my diary? My diary's not relevant. But she had no standing with the court to ask the court to not allow that diary to be put into evidence. And as a result, she was re-victimized during the course of the proceedings, all because the defense team was just trying to attack her as a way of defending the accused. So it's these kinds of cases, they're very serious. And I realize that the majority of Illinois voters probably are going to look at this at the top of their ballot on November 4th and say, what's this? Don't know anything about it, just like I didn't know anything about it some years ago. But this is important, and that's why we're really grateful to you guys for helping us to get the word out that there is actually a serious structural problem in the Illinois Constitution currently that can only be fixed by a constitutional remedy. We can't fix this by statute. Believe me, we've tried. We can't, because the problem, as the Attorney General said in her press conference in Springfield last week, the problem is in the constitutional language itself, and we can't fix that unless we actually amend it. And so, with that said, I will hand it over to Mr. Edmonds, who is my personal hero.
Well, I don't know if there's a lot I can add to that, but I really want to thank you all for meeting with us today. And the first thing I would say, that I'm here as a representative of law enforcement because we really want to let Southern Illinois know that law enforcement is very supportive of this constitutional amendment. And I think it's very important to emphasize, I want to emphasize to you that as you all know and I know, we turn the TV on and we see nothing but negative ads, and there are many races where I'm sure a lot of folks around here would like to vote for none of the above. But this is something on the ballot, and it's the first thing on the ballot that is a hands-down, great, wonderful thing that voters can do. It's a reason to go out and vote, and it is a reason to feel good when you walk out of the voting booth, because this enshrines in our Constitution a right for our victims to be heard in any type of case, but especially in the most serious cases, sexual assault, domestic violence, murder, family of people that have been murdered. And it is so important to understand that when you have rights in the Constitution that you can't enforce, you really don't have any rights at all unless everyone in the court is 100% attuned to your needs and crossing every T and dotting every I. It's really important to understand that those rights have to be enforceable by the victims, and they can stand up in court. And the diary is a perfect example. They can stand up in court, and for whatever reason, the prosecutor and the defense attorney may want to do that, may not have an objection, but the victim has their own interest in that and their own right, and they need to be able to stand up and say that. And it's so important. I see this every day in court at bond hearings or things of that nature, that the victim has the right to have their voice heard. And it's really unconscionable to me to imagine that someone wouldn't be able to give a victim impact statement at a sentencing hearing on a murder. That is...
It happens in domestic violence cases.
And so this is an issue that I just think it's so important that you as an editorial board can educate the public and the likely voters on this issue, because so many people that I have talked to just know nothing about this issue. They would be very surprised, I think, as you probably are, to find out that there are all of these rights in our state constitution that you have no way of enforcing. And it's so important to understand what happens to victims of crime, what they're going through some of the worst times of their lives, and to have these curveballs thrown at them and then to find out there's nothing they can do about them. So as a prosecutor, I see this day in and day out. I see people that are in these situations, and the vast majority of our prosecutors and our judges, I think, are very sensitive to the needs of victims, but you can't rely on that. You need to have an enforceable right so that you can stand up and be heard on those issues. And I couldn't say anything better than what Jennifer said, but I would just really encourage you to seriously consider what you can do to educate the public on this issue, because there are so many other ballot questions, some of them that really don't even have any legal effect, but this is one that does have legal effect, and in fact, a no vote on the issue is a negative vote against it, so it's very important that the public understand that they can vote yes, and they can support and help victims of crime, and that this is supported by law enforcement, that this is supported by advocates for victims across the state, and they can feel good about at least one thing when they walk out of the voting booth, and I really would just want to emphasize that.
Well, I'm Megan Jones-Williams, and I am the coordinator for the sexual assault program at the Women's Center, and I'm also the president of the board of directors for the Illinois Coalition Against Sexual Assault. And I can say that the Women's Center and all of the rape crisis centers and the ICASA staff have been working with ICDV and Marsy's Law for many years, and we are finally at the point where it's on the ballot, and we're so excited about seeing it come to fruition, and so that's why we're here to have your help in getting the word out. I think everyone's explained it very well so far, but we see victims every day at the Women's Center, and our advocates do the very best they can to notify the victims about changes and to help them prepare for court things. But sometimes there's just legal things that are outside of any control we can have to help a victim, and this is one way that will have an enforcement for the rights, and so we feel like we can help to confidently say to our clients, you have the right to this, and we can move forward. You know, if you choose to make a victim impact statement, or if you want to be in court, to be present, and so we're very much in favor of it, and hope that you'll also be in favor of it.
I just want to add about ICASA that the Illinois Coalition Against Sexual Assault were the first people to see the problem over the last 20 years and started calling all of the other stakeholders to the meetings to have this conversation to make it happen. So ICASA gets huge credit for being those people on the front lines of services with victims going through their cases who saw the legal problems without this enforcement mechanism, and so kudos to ICASA for what they've done.
And I want to make sure before I'm sure you have many questions, but as I was listening to you talk, I wanted to make something clear just so that we are on the same page and that everybody in the room is on the same page. The Crime Victim Bill of Rights will not create third-party standing for a victim to intervene in a criminal case. The Bill of Rights will only allow her to stand up in court and have standing to assert these 12 rights that are in the Constitution that are going to be enacted if everyone votes yes. So that's it. And how we've seen it work in other states that have similar language and similar enforcement mechanisms is that it's actually made the process entirely more efficient because judges will take those 12 rights and they'll have it as sort of a checklist to go through as criminal proceedings are moving through to make sure that those rights have been respected even throughout the process and before they have a chance to be violated. So I just think it's important. I know I had said third-party status earlier, and I wanted to make it clear that that's not what's happening here.
Yeah, in fact, are we part of the negotiations for the language? We added specific language that says that victims are not party to the case, to make it clear that the prosecution and the defense, their roles are still sacred. And there's nothing that happens with a victim. Victims' rights are kind of in a different place. They're not on the same continuum as prosecution versus defense. Victims' rights stand independent of that, and there's really nothing in a victim's right to be present, to be kept safe, to be notified, to be heard. None of those things really affect the rules of evidence, how the trial is conducted, the charging decisions the prosecutor's office makes. None of those are affected by just making sure that the victim also knows what's going on and is kept safe in that process.
Yeah, I think it's very important to understand nothing in this amendment limits the discretion or the authority of the prosecutor as the elected official in the jurisdiction, but also nothing in this constitutional amendment in any way impinges on all of the rights that the defendant has. Obviously, he is still innocent until proven guilty, and in no way does this change that or limit or take away any rights. So that's really, I want to emphasize that again, that this is just a net benefit to the public and the system because it gives the victim the right to assert their rights, but it doesn't in any way interfere with the process that we're all familiar with, where the state decides what's going to be charged, and the defendant has every right imaginable to try to contest that and to assert their innocence, and they are innocent until proven guilty.
The two questions that jump to my mind is, A, what was the reasoning behind the original language that would deny these rights? And B, what is different about this time around that the prosecutors find this a good deal where in 2012 you proposed?
Well, I can talk about it. In 1992, it was a political concession, really. I mean, it was a compromise made that we wanted to make sure victims already had these rights in statute, but they did not happen by constitution. So in order to get it on the ballot, it was just a compromise that was made.
So, but I mean, what could be the possible benefit? I don't see that.
Because if they, with the bar, currently under Article 1, Section 8.1A, it lists all the rights that victims have. This is put in 1992. But down in little letter D, in the fine print, it says, but they can't be appealed. And if you can't appeal them, then you can't fix it. The proceeding can't be fixed if a mistake is made. And so, and the reason they did it as a compromise is that they, I think that they wanted to put their toe in the water of victims' rights in the Constitution, but not put the whole, not jump all the way into the pool, I guess.
And it should be stated that right now, the Constitution doesn't state that victims don't have standing to assert their rights. They're in the Constitution, so I think one would assume that if a victim has constitutional rights, she would have standing to come in front of the court and say, hey, judge, please redress this grievance that I have. But that's simply not how it's unfolded.
Actually, I have been told personally, and I know of hundreds of other victims that have been told by the court, you do not have standing. So we have to put that in, we have to fix that.
Yeah, it's a strange thought process, I guess. Why would you have a constitutional right but not have the standing to assert it?
And then, with regards to 2012, the big issue was the attorney.
Yeah, I think, and I wasn't really involved in 2012. I was involved on the state's attorney side this time, and I think there was some concern as to how that it be structured in a way that would not impinge on the prosecutor's discretion as the elected representative of the people, and that it would not impinge on the defendant's rights. And I think some in law enforcement or the legal community raised concerns to the defense bar or the prosecutors about that. But we really went back to the drawing board this time around and got all of the stakeholders involved, and the State's Attorneys Association is very supportive of this, and police chiefs and sheriffs throughout the state are very supportive of this, because we deal with victims every day, and we see them victimized, and what we do not want is to see them re-victimized in the court process. So we're very strongly in support of this.
And in fact, one of the changes that we made was that prosecutors are able to assert the victim's right on her behalf as well. So the victim's attorney, and the prosecutor can all help her stand up in
That's a
court.
very good point. So actually, the state, I believe, could appeal as well
Yes,
if the victim's
yes.
rights are denied, which is a great thing, because we didn't have the right to do that before either. If there was something going on in court that we, as the prosecution, thought was violative of the victim's rights, there's really nothing we could do about it. And so now we have two avenues. The victim could proceed pro se. The victim could retain an attorney, where the state can assert those rights.
So actually, the biggest language piece in 2012, to be specific to your question, was that instead of saying a victim had standing, which now is, I think, the better language that we've come up with, we actually said that the victim had a right to an attorney. We said retained attorney. To be clear, the public was not to pay for that attorney. But even so, there was concern, and I think now, I just think it's a better product now. I completely agree. That, if we'd had the words retained attorney, victim's right to a retained attorney in the Constitution, somebody could argue that the public would have to pay for that anyway. So it's better now that we don't have it. I'm glad that, the process took the time that it took to get to the best language it needed to get to.
So it was never the concept, just the language.
I think that's correct, and I wasn't really involved in that in 2012, but I think that's true. I think, as you find out, the vast majority of prosecutors, I think and I hope, are very sensitive to the needs of victims. So I think it was more of a concern of anytime you're amending the Constitution, obviously the very specifics of the clauses and the commas and the phrases can create all sorts of things. So that's why there were been a series of meetings throughout the last 2 years to get this ironed out. And I know these folks have traveled the state. I had a meeting with them in Benton, and they all came down, and so they've been great. And I think the State's Attorneys Association has really also worked well with them in order to come up with what we think is a great final product.
I apologize for my tardiness, so if you covered this, then I'll just watch the video. Is there a group or groups organized that are advocating people vote no on this?
There's nobody actively working against, no, nobody's campaigning against.
Yeah, we did, you know, in the course of the 5 years really that we've been discussing language in Springfield, a lot of groups have chimed in. Primarily, the biggest opposition came from defense attorneys who, you know, I'm proud to say the Cook County Public Defenders, while in opposition back in the day, have gone to sort of neutral. My sister's a Cook County, but my other surviving sister is a Cook County Public Defender, and she just texted me this morning. She just early voted for it. She told all of the people in her office to vote for it because it's a better product now. But defense attorneys did make a lot of noise during that language negotiation process to make sure that the rights of the accused would not be trampled. I think there are, to be candid, I think there are some of them that are mistaken in their impression that these are competitive rights. That, as you said, they're on a continuum, and they're not. They really are not. There's nothing about my right to make a victim impact statement that changes in any way the presumption of innocence, the rules of evidence, all of the rights, the many constitutional rights that they have. None of them are hurt by a victim also being kept safe, being notified of proceedings, being able to make a statement at sentencing. None of those things are affected. So I think that there are some of them that are fearful that it's going to somehow change the chemistry in the courtroom. Can I be candid? I'll be candid. Why not? There are some defense attorneys that like to use hurtful tricks in there that I think are unethical. They'll put victim on witness lists to keep them out of the courtroom because they don't want. If it won't, we were just talking over at the center about somebody who had a visible. One of the reporters told us about a woman who was set afire with gasoline from her abuser, and she came to court obviously figuratively, very disfigured and scarred. They put her on a list. The defense team wanted her out of the courtroom, didn't want her to attend her own trial because she so visibly looked damaged. And so she wanted very much to be there, but she was kept from the courtroom only because there was no grounds under which she could object to being put on a witness list when the defense team never intended to call her. They just put her on that list because they didn't want the jury or the judge to have to look at her. And that's not right.
I think it's important to note at the same
I'm sorry, I'm very opinionated.
I appreciate, I mean, we can all imagine terrible things like that happening, but I think it's also important to note that these things are still up to the discretion of the judge, and they are still subject to the rules of evidence. So if there is a good reason to exclude a victim from a courtroom, like she is legitimately going to be a called witness, then that's up to the judge to make that decision, and there's nothing in the Bill of Rights that changes that.
They just have the ability to say, wait a second, let's at least review this.
Tell me exactly why you would like me excluded, what you're going to have me test.
It really puts these rights on the same plane as any other legal issue, because the judge has a lot of discretion on a lot of legal issues, but it gives the victim or the state the right to appeal to a higher court to say the judge's discretion in this case was maybe not exercised in the way that we think that it should have been. So that kind of comes back to the core of the issue, which is the judge still runs the courtroom just like with any other issue, but it just makes it an enforceable right, where if there is a decision that maybe is not correct, it can be addressed and it can be corrected.
That goes back to your comment about the diary as well. It would be an option, an opportunity for you to say, let's pursue this outside of the courtroom at first to make sure that it's something that should be.
That it's relevant to the
Yes.
case, that it's
Yeah.
actual evidence,
And
and that
there-
we're not harassing.
And there could be a case where that
Exactly.
type of thing would be very relevant, but there
Exactly.
also can be a case where it is entirely irrelevant. And that's where, and just like with any other, and that's not impinging on the judge's authority, because any issue, whatever the judge decides, we can appeal it to another court, and that's just the way the system works. But these rights, which we have in our Constitution, are excluded from that system.
And really, it's still then up to the judge, you know. Let's say the defense wants to subpoena mental health records of the victim. And that's why we put, you know, we make sure that in this language we've got protections for victim privacy. The victim could object to the mental health records being subpoenaed. The defense could ask for them. You've got competitive motions now before the judge. And then the judge takes those two competitive motions and reads the mental health records and says, yeah, they're relevant to this case, or no, they're not. In the end, it's still the same. The judge makes the finding. The judge determines whether or not it's materially relevant. None of that changes. It just gives victims the opportunity to ask.
Where
because right now
before
they can't.
you had to have a different reason to object besides the victim. Now you can
Well,
actually.
let's just
well,
do You could.
Well, the state could still
Yeah.
object,
Okay.
but the
The
victim
victim
could
can't.
not.
Right,
So
okay.
if the state and the victim have a different opinion, or if the state is not aware of the victim's rights, or whatever the case may be, the victim still has an opportunity to assert that.
Yeah. Sometimes victims are able to call stuff to the court's attention. We're seeing this in other states that have this language now. California was the first place to pass it under the name Marsy's Law, although this language exists in about half of the other states and federal jurisdictions. But, you know, in California, what they have found is that the system is actually working more efficiently. Some people complain, oh, this will slow the system down. Quite the contrary has proven to be true, that now with the checklists on the bench and making sure that they're checking all these things off before they do them, and they're finding that there's better communication earlier on in the cases, because talking to the victim is no longer voluntary, it's mandatory. And they're getting better information, and they're making fewer mistakes. They're actually finding fewer errors have to be corrected, because they're talking to victims earlier, and everybody's voice is heard. And a lot of times victims are able to call attention. You know, it's incredibly hard. My sister is a Cook County public defender. My grandfather was the Champaign County State's Attorney. I watch what prosecutors do every day. This is hard work. What judges do, what prosecutors do, what defense attorneys do is hard. And they work, most of them are all overwhelmed with the number of cases that they have and the amount of information that they have coming at them on a given day. Sometimes you just miss something. And this allows the victim to say, you missed something, when maybe it wasn't intentional. In fact, I'm sure most of these problems were not intentional. This just gives better information to the court, I think, in a lot of cases, too.
Is your concern that in 2 weeks people will go and vote no because no is the default voter reaction to a referendum, because sometimes or often there's spending attached to it, and or because there are other referendum on this particular ballot that, you know, people, we've gone out of our way to say in reality they don't mean anything, they're non-binding this particular time. Is that your bigger concern than the essence of this?
So this is two things that you all can help us with, right? First is that we need people to know that this is not an advisory opinion. This will have an actual effect on victims in Illinois. It's a big deal. It makes a lot of sense. Number two, we sat down, we did the work, we did the legwork with the State's Attorneys Association. We've already talked through everybody in the prosecutorial and the criminal justice system to talk about how this will not place additional burdens on the system. So the victim is not going to be ordered to have a court-appointed attorney that's paid for by any single county. There aren't additional burdens here. In fact, there's a possibility of having a private attorney come in and help us sort those rights. So perhaps another, you know, legal market, I guess. You know, we're all so excited about lawyers. But it doesn't place any additional burdens on the system. So we need people to know that we've talked through all of these concerns with the criminal justice system and burdening our counties, especially our smaller counties that don't have a lot of resources. And we've come up with language that doesn't do that. So,
When you're saying burdens, you're including costs.
yes.
I mean, actually, as I said, from California, we actually have documented proof that this has actually saved money because there are fewer errors, fewer repairs, fewer appeals. In the end, it's actually saving money because the system is working better, because there's more information, there's more inclusion of all the parties. And one of the other things, I think it's probably, I actually am gonna defer to the lawyers, but is it accurate to call this a referendum? This is actually not a referendum, right? This
But
is a
It's a
constitutional amendment.
constitutional amendment.
Yeah.
That
Correct.
is going to take, when people do vote yes,
It will
on
change the
November
language.
4th, on
Yes.
November 5th, it will be in the Illinois Constitution, that day, that very day. So it is going to be a new day on November 5th, in the sense that we will be able to, actually have protections for crime victims in place that other states have and that we do not right now.
And so many other states have this already, and it is very important that the public is aware of this, because if people opt to not vote on this issue, then that is counted as a no vote, because it's a state constitutional amendment, so it is very important. That's why we're here, to try to get the word out on this.
Yeah, you may find this hard to believe, but I don't have my Illinois Constitution on me, so what is the threshold of passage? Is it simple majority, or?
Just help me here.
2 routes.
Yeah.
2 routes to
Two.
pass it. And the reason why there's 2 routes specified in constitutional law is because of the number of people that drop off. Tons of people, apparently, I don't know how many, but a lot of people pick up a ballot vote for governor or president or whatever, and then they drop off. So the 2 paths are 50% plus 1 voter of all who vote, period, in the election. And path number 2 is 60% or 3/5 of everyone who votes on that question. So that's really our threshold. We're going for that 60% because we assume that that's the route that we will be taking.
Don't wait till they get to that on the ballot. They just vote for the races that they're there for and don't finish.
So if either of those thresholds are reached, then it's passed?
Yes.
I love what you said too before about this is something that it will make people feel good to vote on it in this election.
Yeah,
It's such a strange race, and we've got so many negative ads happening right now. It's very disheartening to Illinois voters to have to go in and, make those decisions sometimes, but this will make a measurable difference. It's a good thing.
I would even differentiate it for fear of, making some people concerned that I'm differentiating them, but I am going to differentiate even from the other constitutional amendment. The other constitutional amendment about voter rights is also a binding constitutional amendment and important. It has to do with civil rights, very important issue. But it's being done preventatively because of what's happening in other states with voter suppression laws. And it's not responding to a problem here in Illinois right now. It's preventative in nature. Ours is based on actually years of hard work around a problem we have right now in the Illinois constitutional language. So there's a significant difference even between the 2 constitutional amendments.
Yeah, I think it's actually, our state is solving a problem for once, as opposed to all of the other issues that you all so eloquently write about all of the time that are not solved. This is one where we have a definable problem that we can solve without spending any more money. So I think that's a pretty good sell.
And wouldn't it be typical to say, even if you're skeptical, as many people are, about anything that's on a ballot, wouldn't it be sort of an honest recognition that only Illinois in the entire country managed to create rights for victims and then deny an enforcement? So this is a result of sort of Illinois politics that has to be fixed. It's a way for voters to fix that.
And from the perspective of just working with survivors, this is a way that the general population can help to support survivors on a very simple measure that doesn't cost them any time or money, but is a way to really provide that support.
That's true. Across the state, we've been talking about it's Domestic Violence Awareness Month, and we've been talking a lot after the Ray Rice scandal broke about how people can help victims in their communities. And the easiest way to do it is to vote yes on this ballot. There's no one direct way. There's no one right way to serve a domestic violence victim or a sexual assault victim. They're all different. They all have different needs. And what we try to do is empower them with options and information. And that's what the Bill of Rights is going to help them do within the context of the criminal justice system. Thank you
Thank
very
you.
much.
Thank you so
for
much.
having us
Thank you
today.
so much for taking the time to meet
Yeah,
with us
thank
today.
you very much.
Thank you for coming to talk to us.